Can I ask you what you're doing?
You really need to know what I'm doing?
Yeah, because I got a call here. Okay, no. You don't walk. No.
I'm not walking.
You don't walk towards him.
Sir, I'm on the sidewalk.
You're not
I didn't do
answering
that.
You're not answering questions.
Sir,
I don't have to answer questions.
All right, you're being detained.
Hey,
You're being
where-
detained.
BZ Watchdog News Network.
Before we get started, smash that like button, drop a comment, and share this everywhere, because today we are breaking down another masterclass in how not to understand the Constitution. Today, we're talking about the release of the partial body cam footage, Kansas City Accountability's video, the news report, the Ohio Stop and Identify statute, and the case law that every officer involved should have known before they decided to turn a sidewalk into a crime scene. Because apparently in Ohio now, standing on a public sidewalk while black, recording in public, and asking questions about a bank is enough to trigger the everybody panic button. Nobody said he robbed the bank. Nobody said he tried to rob the bank. Nobody said he went inside the bank. Nobody said he was casing the place with a ski mask, a crowbar, and a getaway driver. What did they say? He was recording. He was asking questions. And then just like clockwork, here comes the Universal Security Guard, the guy who apparently wasn't smart enough to become a cop, but still wants to play one in the parking lot, lighting the whole fire by making it sound way more suspicious than it actually was. And what did law enforcement do? Did they independently confirm criminal activity? Did they observe a crime? Did they see him trespass? Did they see him threaten anyone? Did they see him attempt to enter the bank? Nope. They showed up, started asking questions, didn't like the answers or the lack of answers, and then somehow decided that refusing to participate in a consensual conversation magically transformed into a criminal offense. Folks, this is not how the law works. Under Terry v. Ohio, officers need reasonable, articulable suspicion that a person is involved in criminal activity before they can detain them. Not a hunch, not hurt feelings, not he made the bank uncomfortable, not the security guard said he looked suspicious. Actual facts, specific facts, articulable facts. And under Florida versus JL, the United States Supreme Court made it crystal clear. A tip has to be reliable in its claim of legality, not just good enough to point police toward a person wearing a certain shirt or standing in a certain spot. In plain English, a phone call saying there's a guy recording on the sidewalk asking questions does not equal reasonable suspicion of a crime. And Ohio law backs that up. Ohio's Stop and Identify statute, RC 2921.29, does not say police can demand your papers because you hurt someone's feelings with a camera. It says you only have to provide your name, address, or date of birth if the officer already reasonably suspects you committed, are committing, or are about to commit a criminal offense, or if you are a witness to certain serious offenses. That means the suspicion has to come first, not after the refusal, not because you refused, not because you asserted your rights, and definitely not because some security guard called the police with a dramatic bedtime story. Ohio case law says the same thing. In State versus Whitacker, the court made it clear that anonymous call alone without enough reliable information showing actual criminal activity is not enough. The tip has to point to a crime, not just a person. So when Kansas City Accountability is standing on a public sidewalk, recording what he can see from public and refusing to answer questions during what should have remained a consensual encounter, that does not magically give officers a legal shortcut around the Fourth Amendment. This is exactly what I've said over and over again. Without the officer observing criminal activity or having specific and articulable facts that criminal activity is afoot, the conversation is consensual. And if it is consensual, you can refuse to answer. You can remain silent. You can walk away. But here we go again. Another situation where government employees apparently believe the Constitution only applies when it's convenient. So today, we're going to break down the partial body cam video, the original video, the news report, the Ohio statute, Terry v. Ohio, Florida versus JL, and Ohio case law. We're going to talk about where the officers went wrong, where the security guards stirred the pot, and what Kansas City accountability, or anyone else in this situation, should do when police try to turn lawful recording into a fishing expedition. Because recording in public is not suspicious. Asking questions is not a crime. Refusing to answer questions is not obstruction. And standing on a sidewalk with a camera does not erase the Fourth Amendment. Let's get into it.
Hello, sir.
How you doing?
Good. How are you?
I'm okay.
Can I
How
ask
you
you what you're
doing?
doing?
You really need to know what I'm doing?
Yeah, because I got a call here.
For what?
You recording?
So what's wrong with that?
No, I'm just asking what you're doing.
You're looking at it.
I'm asking you.
Can you please tell him what I'm doing?
Why can't you tell me what you're doing?
I'm recording.
Okay. How hard is that?
Because you're looking at it.
I asked you a simple question. You make it way difficult than it is.
I'm recording.
Okay. Is there a reason why you're recording?
Absolutely.
What's that reason?
I can't share that with you for free.
Why not?
For free.
For free? Why can't you share that to me for free?
Because.
Okay. Well, I can ask these questions to you.
You can ask them.
Okay. It's up to you whether you want to answer them.
It's your right.
So the reason why I'm here, again, they called because
Who did? You called them?
I'm talking to you. He doesn't want to talk to you, sir.
You called them?
Sir, do not about this.
I'm on the sidewalk.
Okay, no.
I'm
You
on the
don't walk
sidewalk.
no.
I'm not walking to
You don't walk towards
Just
him.
put your hands behind your back.
Sir, I'm on the sidewalk.
You're
I
not
didn't do
answering
nothing.
questions.
Sir,
I don't have to answer
Yeah,
questions.
let's just detain
All
you.
right.
Just put your hands
You're
behind
being
your back.
detained.
Hey,
You're being detained.
y'all come in the felony right now. You're committing a felony right now.
I got it.
You're committing a felony. I'm doing legal activity right now.
Sir, you're recording a bank, asking questions about the layout of the bank.
I didn't
Very
ask
detailed
about no
questions. That indicate you may be thinking of a robbery or something. You could be armed. You could be dangerous. Do you have any guns on you?
So let me tell you what you're doing
Let me
right
ask
now,
you, do you have
sir.
a gun on
You're
you?
committing 18
Do
U.S.C.
you have a gun on you?
242.
Sir, just-
This is 241 and 242. This is a felony. What y'all doing right now?
Okay. He has a
Y'all
cannabis in his front
Y'all
pocket. I'm gonna go get that.
depriving my constitutional right now.
What is your
I'm
name?
just
Hold on
recording
to
on the
this.
public
This should be one
sidewalk.
of the reasons we're talking to you.
I'm just recording on the public sidewalk.
Okay. What is your
I
name?
did not agree to no searches and
Okay,
seizures,
so what's your
and
name?
I'd rather not talk to you guys.
What's your name and your date of birth?
I'd rather not talk
You're
to you
either going
guys,
to go to
sir.
jail or you're going to give me your
So what are
name
you
and your date of
detaining me
birth.
for? What's your reasonable? Let's get a supervisor. Let's get a supervisor.
For what?
No criminal activity because y'all don't have no criminal activity.
Okay.
I
You're
didn't
not
do
listening
nothing.
to us.
I'm just on the public sidewalk recording.
What is your name and your
Perfectly
date of
legal.
birth?
Can we please get a supervisor
The
here?
last one asked me, then you're going to go to
Let's
jail.
get a supervisor.
What
I
is
do
your
not
name
want you to
and
make a
your date of
mistake, a
All right,
judge and
sir,
a
You are
prosecutor.
now under
I
arrest
do
for
not
failure
want
to
you.
disclose personal
I do
information.
not
You're
want
going
him.
to jail.
I do not want him to make a mistake. I'm letting him know I'm conducting a First Amendment protected activity. Absolutely.
Okay.
All
I
right,
mean,
sir,
you
you're
guys
now under arrest
for what?
for failure to disclose personal information.
So what's your first?
We suspect you that you're planning to commit a crime.
What
You're
crime?
trying to investigate it, and you're trying
But
to
what
walk away from
crime?
the
I
start.
didn't try to walk away.
Yes, you did.
He said I wasn't detained. You said I didn't have to answer your questions. I mean, I'm not detained.
You're now
I
under arrest.
You're not
wasn't
listening to
Do you
anything
have
we're
anything
saying.
on you that's
Do I have anything on me?
Yeah,
So,
well,
sir, please get your supervisor before y'all make y'all move. I'm conducting.
You're already under arrest.
I'm conducting a First Amendment protected activity, sir.
Okay.
Sir, you can't go to a bank and start
I'm not
asking
at
things
the
like,
bank.
when is
Again,
your
you're
security get off?
You're
I'm not
interrupting.
in-
What is the floor layout of the bank?
Let's
Start
talk
trying to
about it.
record the security coming in and out. You can't do that. Okay? You understand why that would lead people to think you're planning a robbery of the bank.
I'm out here exercising my First Amendment right to record in public peacefully.
Okay, well, you're under arrest, sir.
Okay, for what?
For failure to disclose.
Failure to ID is a Second Amendment offense. What's the first crime that I committed? Hey, can we get your supervisor here? He's making a big mistake. This guy right here is making a huge mistake. You're making a huge
Look
mistake.
at that. I bet you have an idea.
I don't agree with no searches and seizures. You
Okay,
said to
that's
me.
fine.
We're threatened.
I didn't say that. They came and talked to me. I'm on the sidewalk. I have every right to be on the sidewalk.
Okay.
And he's going through my wallet.
Yes. You're under arrest.
Okay, for what crime?
We already explained that to you. You keep repeating yourself. You don't want to listen.
Okay, say the
That's
crime.
not. We already did.
You said for not answering questions.
Not disclose your information.
I don't have to do this,
Yes,
sir.
you do. If we have a reasonable suspicion that you have or going to commit a crime, we have.
What's your reasonable articulable? I'm committing a First Amendment protected activity.
He just explained that to you.
Okay.
He just explained it.
Okay, sir. This is okay.
He must have.
When I made contact with him, because I came outside to see what he was doing.
How was he out here for a while?
Yeah, he was out here for a while, and I thought he was one of those First Amendment auditors.
Okay, yeah.
So I'm like, hey, how are you? What story are you doing? Because from what I seen on YouTube, they stories or whatever. He said, I'm doing a story for my employer, and can I use the Wi-Fi? So I come in here to ask them could he use the Wi-Fi. They tell me no, so I come out here and I tell them no.
Okay.
And then he asked me, well, how many employees are inside? I said, I can't give you that information. And then he asked me, I don't see you guys' vault, like looking around. I don't see you guys' vault. Where's that located? I said, I can't give you that information. I came right back inside and called you guys.
Okay. All right.
I'm like, oh, that's way suspicious. Like, you trying to set us up or something.
Yeah.
Now, listen to what just happened here. You just heard these officers getting a statement from the caller after Kansas City Accountability had already been detained, placed in cuffs, and arrested. That matters because that means they were trying to build the case after the seizure already happened. They were trying to take this defective detention, this de facto arrest, and make it look airtight after the fact. But the Fourth Amendment does not work backwards. You do not detain someone first, arrest them, then go shopping for reasonable suspicion later. Ohio Revised Code 2921.29 is very clear. Before an officer can lawfully demand a person's name, address, or date of birth, that officer must have reasonable, articulable suspicion that the person has committed, is committing, or is about to commit a criminal offense. And about to commit does not mean maybe. It does not mean someday. It does not mean the security guard felt uncomfortable. It means there must be specific facts showing that criminal activity is immediately about to happen. Not hunches, not feelings, not assumptions, not suggestions pulled out of a consensual conversation. And definitely not, well, he would not answer our questions, so now we think he's suspicious. Folks, refusing to answer questions is not a crime. You have a Fifth Amendment right to remain silent. And to be fair, Kansas City Accountability probably should have made that even clearer by saying, I invoke my Fifth Amendment right and I'm not answering questions. Let's be honest, even without those exact magic words, silence does not create reasonable suspicion. Refusing to cooperate with a fishing expedition does not give police permission to escalate a consensual encounter into a detention. That is the part these officers either forgot, ignored, or hoped nobody watching would understand. They did not observe him commit a crime. They did not see him trespass. They did not see him threaten anyone. They did not see him attempt to enter the bank. They did not even talk to the complaining party first to confirm what was actually being alleged before they turned this into a detention and then a de facto arrest. They had a guy on a public sidewalk with a camera. That is it. And this is where Terry v. Ohio matters. The case that started right there in Ohio made it clear. Police need specific and articulable facts that criminal activity is afoot before they can detain someone. Not a vibe, not a phone call with vague claims, not a security guard acting like public photography is a felony. And under cases like Florida versus JL, the United States Supreme Court said a tip has to be reliable in its claim of illegality, not just identify a person standing in a location. So if the caller says there's a man recording, that may identify the person, but where's the crime? If the caller says he's asking questions about the bank, okay, where's the crime? If the caller says he's on the sidewalk again, where's the crime? That is the question every officer should have asked before they ever put hands on him. Because once they detain him without reasonable, articulable suspicion, everything after that starts looking like damage control. Now they need a statement. Now they need the caller to say something stronger. Now they need the paperwork to look better than the body cam. Now they need to justify what they already did. That is not investigation. That is after the fact case building. And the Constitution does not allow officers to violate your rights and then go back later trying to find a reason why it might have been okay. That is the problem here. Kansas City Accountability was not arrested because officers saw a crime. He was arrested because he refused to play along. He refused to answer questions. He refused to help them manufacture suspicion against him. And that is exactly why the Fourth and Fifth Amendments exist. Because the government does not get to turn silence into guilt. The government does not get to turn lawful recording into suspicious behavior, and the government does not get to turn a sidewalk into a crime scene just because somebody with a badge or a security shirt does not like being filmed.
Tonight, a man is out of jail after being arrested by Cincinnati Police while he was recording video downtown. Thanks for joining us at 10. I'm Tricia Mackey.
And I'm Rob Williams. I went out and talked with a man arrested in this video you see behind us.
So this is from yesterday afternoon when he says that he was trying to teach people about their First Amendment rights.
I try to put people on notice. I try to let people know about rights I try to put you on notice about rights that you may or may not know that you have. I teach people how to deal with hostile situations and how to deal with law enforcement respectfully.
People would say to you, wouldn't it have been just easier for you to just tell them your name and what you were doing there?
Absolutely.
That would have been an easier path, but why did you choose this one?
Because I like to let people know that you do have a Fourth Amendment right to be secure in your persons, papers, housing, and effects from illegal searches and seizures. Because people will take advantage of you not knowing your rights.
When asked about his interaction with Cincinnati Police, here's what he said. You can see in the video, bike officers rolling up to question him while he's recording.
It was horrible. I was really shocked that it even happened because I was eventually going to go in some of the government buildings, which is public. But to get a feel on the police, I decided to do the first one on a public sidewalk, which is traditional public forum. And police supposed to be aware of this.
I went on to ask him about recording in front of a bank and how that may have made people nervous.
Where your feelings start, my rights don't stop.
He's been to 13 separate states and done something similar to what he did here in Cincinnati this week. I asked why it's important for him to do this respectfully.
My work is intended for the younger generation, and they have a bad reputation of just being disrespectful to authority, to their elders, and to each other. So if they look up to me and they watch my videos and they think I'm, a cool guy, and they see me being nothing but respectful for everybody, they will follow path, because the youth, they mimic what they see and they repeat what they hear.
Allie Henner spoke with experts on how his arrest and how police responded.
So, Allie, what did you learn?
This is kind of a complicated situation. I did speak with our legal expert about this. He says this is an issue of balancing one's First Amendment right to do things that are permissible under the Constitution versus violating criminal law. Now, Cincinnati Police policy states that recording in public is a lawful activity and not suspicious on its own. Now, in this case, Moses was not charged for filming on a public sidewalk, filming that bank you saw in the video, but for not disclosing personal information. Moses is charged with failure to disclose personal information, a fourth-degree misdemeanor.
To me, it's not a real obvious situation. The thing that we're missing here, we don't know what the officers knew.
Mark Crumbine, a Cincinnati defense attorney, says under the law, there are two reasons for someone to be arrested for not disclosing personal information in a public place.
One is if there's a reasonable suspicion of a criminal offense, that would be number one. And then number two, that they might be a witness to an offense, a serious offense, or an offense of violence.
Crumbine says the issue is, can police prove he was required to give his personal information?
The complaint alleges that he was inquiring about bank security. So I think that's what the police are saying, why that they had a reasonable suspicion that he might be committing a criminal offense.
According to the Cincinnati Fraternal Order of Police, Moses had asked how many employees were working at the bank and where the vault was located, which made employees so worried they called 911 to have police respond. And if any officer has reasonable suspicion that a crime has been, may be, or will be committed, they have every right to identify a quote-unquote suspect.
We have an individual that's filming outside of the bank across from Pyatt Park in downtown Cincinnati. So basically, legally and common sense wise, it's okay to make a video out in public. People do it millions of times a day, especially with cell phones and
Cincinnati FOP releasing a statement saying, after reviewing the video, it's clear the auditor simply bit off more than he could chew. CPD officers responded, investigated, and made an arrest that was based off of what the law says. Being a self-proclaimed First Amendment auditor doesn't insinuate you are breaking the law. It appears this auditor needs to brush up on the Constitution and the Ohio Revised Code before acting in an unlawful manner. So Cincinnati police also are asking for the community's patience as this incident is investigated internally and by the city's Citizen Complaint Authority. Now, failure to disclose personal information in Ohio is punishable by up to 30 days in jail, a $250 fine, or both. Rob, Tricia.
You know, I've seen a lot of these videos of people that do the same thing, and they usually go viral, and that's why they do it. Mm-hmm. But it's always like, you don't have to do this, you don't have to do this, you don't have to comply. But really, it varies. Correct?
Yeah, after speaking with Mark Crumbrine, our legal analyst, he compared this to a situation involving traffic stops, where if they suspect that you're speeding or if you miss a stoplight or don't use your turn signal, you're under suspicion of committing a crime, so you have to divulge your personal information. With this situation, it kind of went viral on social media. Everyone figured, oh, well, he doesn't have to divulge his personal information because he wasn't committing a crime. However, Cincinnati police had suspicion that he might be. Police were worried that he was maybe casing this bank, taking videos inside the bank, asking about the security of the bank. So Crumbine says he believes this will eventually go to a trial.
Well, he will be back in town for his trial date, which is set on June 17th. And he says he's going to get here a couple of days early to prepare.
I think the language in that is pretty broad also. It's kind of like, art.
And there it is, folks. You just watched the whole thing play out exactly the way unconstitutional detentions usually play out. They didn't detain him because they observed a crime. They didn't detain him because they saw him trespass. They didn't detain him because they saw him threaten anybody. They didn't threaten him because they saw him attempt to enter the bank. They detained him after he refused to answer questions. And that's the problem. Because if they truly had reasonable, articulable suspicion from the very beginning, then why was this not a detention from the moment they walked up? Why start with, can I ask you what you're doing? Why tell him it is up to him whether he answers or not? Why treat it like a consensual conversation until he actually exercises his right not to participate? That is where this whole house of cards falls apart. Because the moment Kansas City Accountability decided he was not going to play 20 questions on a public sidewalk, suddenly these officers wanted to turn lawful silence into suspicion, lawful recording into criminal behavior, and a public sidewalk into a crime scene. And then, only after the cuffs come out, here comes the after-the-fact cleanup crew. Now they need a stronger statement. Now they need the caller. Now they need a security guard. Now they need to make the paperwork sound better than the body cam. Now they need to backfill reasonable suspicion after the de facto arrest already happened. That is not policing. This is damage control. And let's call it what it is. These three little pigs built their case out of straw, sticks, and speculation. And the big bad wolf called the Constitution is going to huff, puff, and blow that garbage right into suppression hearings. Because he could be casing the bank is not reasonable suspicion. He might be planning a robbery is not reasonable suspicion. He asked questions is not reasonable suspicion. He recorded from a sidewalk is not reasonable suspicion. He would not answer our questions is not reasonable suspicion. That is not law. That is a bunch of hypothetical ifs dressed up in a police report. And I strongly suggest these officers, the Cincinnati PD, and the Fraternal Order of Police go sit down with a highlighter and actually read Terry v. Ohio, Florida versus JL, and Ohio's own State versus Whitacker. Because after nearly 60 years of established Fourth Amendment case law, they still seem confused about the difference between a fact and a fairy tale. Terry v. Ohio does not say cops get to stop people because they are curious. It does not say cops get to detain people because a security guard is uncomfortable. It does not say cops get to create suspicion after someone refuses to talk. Terry says officers need specific, articulable facts that criminal activity is afoot before they see someone. And Florida versus JL says a tip has to be reliable in its claim of illegality, not just good enough to point to a person standing in a certain place. And in Whitacker, Ohio courts made the same point. A call that identifies a person is not enough unless it actually points to criminal activity. So when the so-called crime is a man on a public sidewalk with a camera and the suspicion is built on what he could be doing, then we are no longer talking about reasonable suspicion. We are talking about imagination. And if this is how Terry is going to be abused, if officers are going to twist reasonable suspicion into, I can imagine a possible thought crime, then maybe it is time for the courts to stop giving government this much wiggle room and force them back to the standard the Constitution was supposed to protect in the first place. Because your rights should not depend on whether an officer can invent a scary enough what if after the fact. This should be the kind of case that makes everyone ask whether Terry has been stretched so far that it is no longer a shield for officer safety. It has become a shortcut around the Fourth Amendment. Kansas City Accountability was not arrested because officers had a crime. He was arrested because he would not help them build one. He would not answer their questions. He would not surrender his rights. He would not make their fishing expedition easy. And that is exactly why the Fourth and Fifth Amendments exist. Because silence is not guilt. Recording is not suspicious. A sidewalk is not a restricted area. And could be is not reasonable articulable suspicion. Before we go, smash that like button, drop a comment, and share this everywhere because sunlight is the best disinfectant. And I'll leave Cincinnati's information down below just in case anyone watching wants to peacefully and lawfully redress their grievances with the government. Because if they're going to put citizens in cuffs for standing on a sidewalk with a camera, then they should expect the public to show up with cameras, records requests, complaints, and lawsuits. This is BZ with BZ Watchdog News Network. Know your rights, use your rights, and never let the government employees convince you that the Constitution only applies when they feel like honoring it.
Tyranny, corruption, extortion. Sunlight is the best disinfectant.
BZ Watchdog News Network.